What's up, guys? We are going to try to cover this hearing. However, as you can see on my screen here, it looks like they might not want to allow me to. Here we see in the waiting room, uh, they have asked me what I'm here for. You say I'm here to observe. This is a courtroom, open court, right? Does not the public have the right to witness the proceedings? Well, apparently, according to this, we likely will not be going on record. If we do, you would need to observe on YouTube. So I've asked them for the correct link. We'll see, folks. We might not have much of a stream today if we are not able to get any live video because apparently this court is not quite as open as it seemed to be. But we shall see. We shall see. I do have what appears to be their YouTube page open. Apparently, they only actually have any videos on there when they are actually live. She is not confirming. I'm assuming the clerk. So she has not confirming that this is the correct YouTube link, which is the one that was included in the notification I got. But there it says we will likely not be going on record, in which case we will not have much of a stream today, folks. Now, what I will do is tell you what, I'm going to keep this window open. I'm going to push it up to the above screen and maybe talk for a moment or two about what this what should be happening right now. And we'll see. We'll see if we can actually get a stream going, if we can actually get any footage. Yeah, this is what their YouTube page looks like. I thought I had this pulled up when I was going through it, but there is apparently nothing here. But that may change if they actually start streaming live. But in the meantime, we are just stuck with this, getting stonewalled by the clerk. So we will see if that changes. In my humble opinion, you know, unless a court has a special reason why they need to go private, judicial proceedings should be public, especially in a very high public interest case on this. Ruffled Feathers on YouTube says, try courthouse link. Ruffled Feathers, if you wouldn't mind posting that link in the chat, I will hop on it. I thought this is their link, but if this is not the right one, this one here, if this is not the correct link, please correct me. But I think this was the link to their YouTube page. I can try something else. But let's see if they've. Okay, she says they're saying if I go to accesskent.com, I can find the link. Let's see. I'm going to go to that now. Access Kent. Oh, this will be fun. If anyone has the direct link, please send it to me. Hearing schedule. Is that where we go? Let's try this. Party last name. Karamo. Oh, I need to do more than that. 8/30th. And not a. Oh, give me a break. Oh, that's a truck, not a bus. Verify. Okay. Status 9 o'clock. Adjourned. Really? Courtroom 8A. Okay, there's nothing here that's giving me a link to view anything live. Courts. Court services. Maybe here. Folks, if you're watching, if you have any better way to try to watch this live, let me know. I'm going to refresh this YouTube channel again, see if this does any good. Still not here. Let's see. Yeah, nothing more from the clerk. Yeah, just go to accesskent.com. You can find the link. Thanks. That's very, very helpful. Let's see here. There's so many different places this could be. Clerk of the Circuit Court, maybe? No. Hearing schedule. No, I was just there. That didn't do me any good. Uh, on Facebook, DC Pickering says the judge's personal YouTube is only for the parties and their attorneys. Patty P says, is there still hearing? Are they in chambers? They could be starting late. We were trying to just find the feed. The court clerk has been completely unhelpful. They won't let me into the Zoom. They say go to the YouTube channel. They say to go to accesskent.com to find the YouTube channel. If anybody in chat can find where to find this dang YouTube channel for the courtroom, let me know. I will show you. Here's the notice that I got. And that YouTube channel is the one I've been checking in on periodically. So this is what I got. It so far has done me no good. Is there anything on here yet? Nope. Todd Gilman says there is no stream today. So just to give you guys the story, what I have heard is that Daniel Hartman told the court that there was going to be he didn't get noticed, he claimed, over the hearing on the temporary restraining order, but there is supposed to be a hearing on the Hartman motion to dismiss, which is all about the question of, is his Hartmanist defense allowed? Todd says lawyers only. Okay, well, we'll see if we have any. If they're having a hearing, it doesn't mean the parties have to be present. So we'll see. We'll see. I'm keeping an eye on my text. If anybody else out there, and I know there's some attorneys who are also trying to get on the courtroom, we will see if we have any ability to get any kind of footage. Yeah, John, I got the same exact. Oh, it's a scheduling conference. Okay. If we go on record, you may want. Yeah, see, that's what they told me too, and they told me nothing more than that. Yeah, see, that's what they just posted here too. With, again, no link to the YouTube. There is this YouTube, but so far there seems to be nothing there. So, tell you what, if anybody has the right link, let me know. If not, well, here's what I'll briefly do. Since we are live, and there may not even be any stream at all, let me just real quick talk about what this Hartmanist stuff is all about, because I never actually went over what Dan Hartman filed in response to the lawsuit. So we can go through this briefly. Let me pull it up here. Hold on. In the meantime, folks in chat, if anybody has any leads into how we can get a live feed into the hearing, please do let me know. Post a link or something. But in the meantime, here, let me just pull this up. This was actually posted by Dan Hartman literally the day after the lawsuit was filed. So the lawsuit was filed on a Friday. This came out, I think, Saturday or Sunday. Hey, Jonathan, we see you there on Facebook. We are trying to get a hold of a live feed. It looks like it may not happen. Looks like the court's not going to allow the public to view this hearing. That may change. I'll keep an eye out on that. But so far, there is nothing. But I think there's some folks who are trying to get a window into it. And if they do, they'll let me know as well. And same if anybody else watching has any ability to find a feed from the court, that would be lovely. Otherwise, we may not get to actually watch the thing live. Anyway, so this is what Dan Hartman had announced he was filing on the weekend immediately after the lawsuit was filed. So we can look through this real quick, because this is their motion for summary disposition. This is what apparently they're going to be talking about today, although maybe not, because in the chat, the clerk made it sound like this was a scheduling conference. So maybe they're just rescheduling things. The latest I heard yesterday was that Dan Hartman claimed that he was not properly served the notice of the hearing for today on the temporary restraining order that Melinda Pago and company applied for. And there's going to just be a hearing on this motion for summary disposition today. Which is interesting, because this motion is based entirely on just telling the court, you can't hear this. And we'll look at this. Hold on. Can't answer that one. I don't know who that was, but there's an unknown number on my phone, so I'm not answering it. Michael Pilabosian says, I call the KK Club the Jonestown cult. There you go. Anyway, so this is Dan Hartman's motion that is supposedly being heard today, but maybe it won't be. I don't know anymore. Melinda Pago, Ali Hossein Hassan Naimi, missing a comma. So apparently the two people are one person. Ann Delisle, name misspelled. Jessica Bearfield, Norm Schinkel, name misspelled. Plaintiffs versus Kristina Karamo, defendant. There you have Jonathan Louderbox, name also misspelled. Defendant Kristina Karamo's motion for summary disposition, oral requested. Defendant Kristina Karamo, through her attorney, Daniel J. Hartman, moves this honorable court to enter an order of dismissal pursuant to MCR 2.1164 and enter a summary disposition for lack of subject matter jurisdiction for the reasons that the matter is not justiciable by this court pursuant to the Hartmanus doctrine, which is a reference to a case that is also misspelled. So we have a lot of misspellings and typos right there on the cover page. Not justiciable because of the Hartmanus doctrine, concerns a political question, and has been resolved by the Michigan Republican State Committee. That is the sole authority for interpreting its own bylaws. This is basically a pile of gibberish. We will go through it briefly. And I guess we'll imagine what's being said in the courtroom right now, assuming that they're actually having a hearing right now on this motion. And it's not very long. This is their brief in support. And it's basically saying you can't do this because the subject matter is outside the court's jurisdiction. The court doesn't have subject matter jurisdiction because it's an intra-party dispute. And how is it an intra-party dispute? Well, they don't really actually ever say. Real quick, a text came in, so let me see what this is. If this is going to help me get an access to a live feed, let me just double check again if there's anything live going on their channel. There is not. Icepick says, who is the judge on this case? Each judge should have a YouTube live channel. I believe it is Judge Rossi is the judge's name. Oh, I got a text from that unknown number. No, it's something unrelated. Okay. Jonathan Chapman says, Dan did go to the worst law school in the country. Google it. It seems that way. Anyway, so what they're basically arguing here in this brief is that the court has no right to hear this case because of the doctrine versus in Hartmanus v. Austin defines the limits of the state's ability to regulate the internal processes of the party by the Sixth Circuit, which blah, blah, blah. This is all complete gibberish. And let's look. I'll show you why. I'll show you why I say that. I'm going to pull up the actual Hartmanus case. So you can see what Hartmanus is actually all about. This is the Hartmanus case. Let me see if I can zoom in on this a little bit. There we go. That's better. This is a 1988 case. George Hartmanus et al. V. and Michigan State Republican Central Committee versus Richard Austin, Vernon Ehlers, and others defendants. Oh, so this is a Michigan elections case. That's about as much as the two cases have in common. And here's what the story is all about. Plaintiffs bring this constitutional challenge to several sections of the election law. That's a bit different than this current case. The state statute grants automatic delegate status at state and county conventions, as well as automatic membership on county executive committees, blah, blah, blah. As such, the plaintiffs say the statute violates their First Amendment rights, and the defendants say, in addition to arguing the constitutionality of the state statute, raise several procedural barriers. So what's the issue? The issue is that these plaintiffs who are members of the state committee are arguing with defendants who are state office holders who say they have a right under the statute to participate as at-large delegates or precinct delegates. And here's the issue. As a result of the conflict between the state central committee attempting to enforce newly adopted delegate selection rules and intervening defendants, office holders, and nominees asserting statutory right to participate in county conventions, competing delegations have been elected in the county conventions. So here's what this case is actually arguing about. This is important because this is what Dan Hartman is saying is the grounds for this court not being allowed to hear this case. He says, look at Hartmanus. Look at the court said. Well, here's what the court said in Hartmanus. There's a case where the plaintiffs are saying, hey, judge, can you rule this law unconstitutional? And what does the court say? Well, they say, it's funny, there's this national party rule here And it says, Republican National Party rule adopted in 1980 RNC did not permit automatic delegates at any level of delegate selection procedures who serve by virtue of party position or elective office. So I'm skipping through to the parts that I've highlighted here. The relevant part about this is, hold on, we're still going here. This is a case involving the selection of delegates by political parties, not the issue of who is the chair of the party, for one thing. So this is kind of distinguishable. Here's what the court says in this Hartman's case. The distinguishing feature in this case is the National Republican Party's decision to incorporate state laws into the National Party rules. In short, the National Republican Party, not the state statute, is responsible for the alleged infringement of plaintiffs' constitutional rights. So what's the Hartman's case saying? It's saying there's a lawsuit here asking for us to hold this law unconstitutional, but we can't see any reason why this isn't any of our business because the National Party has adopted the state statute. Therefore, this case has nothing to do with us. And here's what they say at the end. This court cannot afford plaintiffs effective relief without joinder of the National Republican Party. The declaration by this court that the state election statute is unconstitutional would have no effect on the Republican National Party. Therefore, why are you here? Plaintiffs, in effect, seek to overturn the rule by having the statute declared unconstitutional. That, therefore, would involve the court in internal matters of the Republican Party and thus impinge constitutional rights because they're asking the court to say that the Republican National Party's rules are wrong. So they say in violating the, and I highlight this because invalidating the election statute is what this case asked the court to do. It's not the role of this court to strike the balance between the involvement of party nominees and office holders and the more recent Republican Party members in the governing of the state party. In other words, none of this has anything to do with the case of Melinda versus Kristina. This court finds little merit in the constitutional challenge to the election statute. Plaintiffs nevertheless maintain the statute should be declared unconstitutional on its face, and they cite these other cases. None of those cases involve situations in which a national party, in the exercise of its First Amendment rights, voluntarily incorporated state law in its national party rules. As a result, the cases offer little support for the plaintiff's facial challenge. In one case, the state party adopted a rule permitting individuals who are not registered members to vote in the primary. The court invalidated a statute, and here's the important thing. They're saying this case you're citing is talking about invalidating a statute. In this other case, a state party can't be required to follow the election statute if the statute violates the national party rules. Significantly, the district court in that case emphasized that nothing in its opinion was intended to suggest that the election statute was unconstitutional on its face. And lastly, the court in this other case they cited invalidated a state statute. And this has nothing to do with invalidating statutes. The election statute offers one method by which a political party, if it so chooses, may select convention delegates. And that may have some political advantage to one party over the others, but that's no basis for declaring the statute unconstitutional on its face. And that's the end of it. That is the end of the Hartman's case. So what's the Hartman's case? It's the court saying, okay, these cases that you guys have cited are not relevant. They're distinguishable. They don't have anything to do with this. And we can't give you the relief you want to say that the state statute's unconstitutional because it's what your party rules say, what your national party rules say. So even if we were to hold the statute unconstitutional, which we're not going to bother with because you haven't given us reason to, because it's in your national party rules anyway, it still wouldn't matter because it's your national party rules anyway. So that's the Hartman's case. It is not any kind of landmark case on anything. It's a case where the case was dismissed, saying the other cases you guys have cited are irrelevant. So that's the Hartman's case. And that is the entire basis of this motion to dismiss. There's no rebutting anything in this brief on anything that Melinda Pago and the others made in their suit, because that's not what they're arguing here. They're just saying, just dismiss the case because it's Hartman's. It's Hartman's. And what they've done is they've found a case where some of the words in the case can be cherry picked. So, for example, they'll quote this. Simply put, the equities do not. This is in what case are they citing here? Okay, it's another case, but they're cherry picking out these cases where they have quotable quotes that sound good. Simply put, the equities do not warrant this court assume it's sparingly exercised and carefully circumscribed authority to intrude into the process of political party. So here's what Lauterbach is going to probably be arguing in court right now. If they're having a hearing on this today, which I'm not entirely sure they are anymore, it might only be a scheduling hearing. But Lauterbach's saying something like, Your Honor, this Hartman case has nothing to do with the matter before us here. It was a case that was not really precedent setting in any way, shape, or form. It involved trying to invalidate a statute. And it was because all the court in that decision said was that your national party rules override the state's rules, and therefore this case has no meaning. This is not a case involving an intra-party dispute. This is a case involving the challenge of who is in a party. It would be as if, Your Honor, there was a disputation within a board of a corporation over whether a vote was taken properly under the bylaws. And the question is, who controls the company now? That's not an intra-party dispute. That's a dispute between two parties. This is a bunch of gibberish. You should, for that reason, Your Honor, dismiss this ridiculous motion. That's what's probably being said in some way, shape, or form here today, if they're having this hearing. Let's go back and see if we can actually get anything into the court. I've been removed from the meeting by the host, apparently, so that's no good. So we're definitely not getting in that way. Let's see. Yep, I've been removed from the meeting by the host. So much for that public's right to know stuff. We can try refreshing this again. Let's see. Looks like nobody in the chat's had any better luck getting a hold of the stream. And I don't see. Oh, I got a text from Matt DePerno saying, yeah, this is not intra-party decision. It's a breach of contract issue. Exactly. That's what I'm going to say. Your Honor, this is a breach of contract issue. You do have the ability to decide this. That's what's going to come up. And they're going to cite case after case after case. I mean, this is, well, I'm sorry we're missing out, folks. It looks like even if things are going on, we wouldn't be able to get in. We might have to try and work harder to get a live stream of any future proceedings. But it looks like, unfortunately, folks, this is going to have to do it for us for this morning. Follow us on X. We will post whatever we hear about whatever came out of the courtroom later this morning. But it looks like we're not going to get a live feed after all. And unfortunately, I don't think there's anything we can do about that. I mean, maybe in the future we can petition the court to have future hearings on this case live streamed. But nothing for this morning, unfortunately, but we will certainly keep you guys posted. So until next time, tomorrow night, 9 o'clock. Talk to you then. See ya.